Hello. First of all, let me introduce myself. My name is Luis Fernando Rodrigues Pinto Jr. I am a public prosecutor of Public Ministry of São Paulo State, Brazil. I belong to an institution whose profile is outlined in Article 127 of the Federal Constitution of Brazil of 1988. And where the system of entry into the career of public prosecutor takes place through public examinations and titles. I personally joined it in November 1989 after a one-year competition with 5 phases, 3 written and 2 oral. And this position is for life. You will listen more about this in a few minutes. I was invited for this speech as part of the celebration of the World Constitution Day on August 1st, 2021. And I wish to say thank you to my friend, Professor Nicholas Merloni, and also to Jim Scherer, coordinator of the World Constitution Day, for the invitation. You are going to listen something about the profile of public ministry in the Constitution of Brazil and the defense of democratic order and citizenship. So, welcome to this brief talk. Well, I'm here to talk to you about the profile of the Brazilian public ministry, in which its members have as their main goal the defense of the democratic state of law, the legal order, and the defense of citizenship with protection of unavailable social and individual interests. Before the technical and legal remarks on the subject, I would like to remind you of the reason why a society organized under the edges of freedom, that is, with a political system that accepts the diversity of ideas, based on the principles of democracy, needs to know how to divide and balance the power of those who can command. Otherwise, if power is concentrated in the hands of a single person, of a single dominant group, we will not have respect for the freedom of the citizens that make up a given social grouping. Well then, Brazil, like many of the nations of the world, has its political system based on the classical division from the original idea of Aristotle and the systematization of Montesquieu, in which the functions of power are divided between the executive power, here, mayors in cities, governors in states, and the president of the republic at the federal level. The legislative power, they are called aldermen in the cities, state deputies in the states, and the federal deputies, as well as senators, to houses at the federal level. And third, the judiciary power. And here there's a division between the federal and state levels. They are parallel. Then the Superior Court of Justice and the Federal Supreme Court are the highest instances, the latter being responsible for protecting the federal constitution. We know that sovereignty is only one, but it is necessary to make use of the division of functions between who should make the laws, who should apply the laws, and who should control their application, with the respective protections and punishments, establishing a system of breaks and balances between the bodies that exercise such sovereignty. In a creative and intelligent way, I think, the Brazilian Constituent Legislator of 1988 placed the figure of the public ministry, which until then was under the executive power, independently of the other 3 powers, although not truly a 4th power. The structure is identical to the others, including in terms of autonomy, guarantees, and prerogatives. Chapter 4 of the Federal Constitution of Brazil is called From Essential Functions to Justice. And its first section, it says, from the public ministry. By definition, Article 127 says, the public ministry is a permanent institution essential to the jurisdictional function of the state, responsible for defending the legal order, the democratic regime, and unavailable social and individual interests. Being permanent means it cannot be extinguished. Figure as a permanent clause in the federal constitution. Of course, we're not thinking about the hypothesis of a revolution that can cause a big change and kill the constitution. It's not the case. The MP, as we call here the public ministry, because in Portuguese we say Ministério Público, acts as a defender of society's collective interests from protection in the criminal area, where it has the exclusivity to file criminal action before the judiciary, through the protection of diffuse rights, such as the environment, consumer, housing and urbanism, public property, indigenous and minority rights, and still acting to protect the democratic regime and the legal order. We will talk more about this later. Let's talk now about the principles that govern the public ministry. They are unity, indivisibility, and functional independence. The principle of unity states that whenever a member of the public ministry is acting, regardless of the subject, time, and place, the action will be legitimate as long as it is aimed at achieving the institution's purposes. All members are part of a single body under the direction of the same head, and the division into different bodies exists to allow the rational division of labor, but all must act for the same foundations and for the same purposes. When a member acts, he does it on behalf of the entire institution. The indivisibility principle indicates that who is present in the records of the process is the public ministry institution through the member who acts. Thus, if the prosecutor of attorney for justice who is acting in a certain process is promoted to another position, retires or dies, for example, the other person who will replace him or her does not cause any changes in the process. It will be a continuity. The principle of functional independence means that the members of the public ministry, in the exercise of their functions, act independently without any hierarchical subordination bond, including in relation to the head of the institution. The conduct of the prosecutor or attorney for justice is guided only by the law and its convictions, and submitted to the appreciation of the judiciary. Hierarchical subordination only exists on the administrative level and not at the functional level of the final activity. The federal constitution guarantees also to the public ministry functional, administrative, and financial autonomy. This means that there is administrative self-management with its own budget allocation, prepared by the public ministry itself, and also with the initiative of the legislative process aiming at the creation of their positions and the auxiliary service through public examination. The budget proposal and the bill must be sent to the legislative power, which will debate. All these are to guarantee the effective independence. Well, let's talk about the internal division. We have the Federal Public Prosecutor's Office, which comprises the Federal Public Ministry, the Public Ministry of Labor, the Military Public Ministry, the Public Ministry of the Federal District and Territories. And second, the State Public Ministries, which also serve the respective municipalities. The Attorney General of the Republic is the head of Federal Prosecutor's Office and is appointed by the President of the Republic among career members over 35 years of age after the approval of the name by the absolute majority of the members of the Federal Senate for a term of office of 2 years, renewal allowed. On the other hand, the general prosecutor of a state or of the federal district and territories is chosen by the head of the local executive power from a triple list formed among members of the career, where all the members vote in an internal election. To a 2-year term, one reappointment permitted. To dismiss the Attorney General of the Republic only on the initiative of the President of the Republic and with the authorization of the absolute majority of the Federal Senate. As for the general attorneys in the states and in the federal district and territories, they may be removed just by deliberation of the absolute majority of the local legislative power in the form of the respective complementary law. Let's talk now about the nomenclature, the names. It's a little difficult because even in Portuguese, sometimes there are kind of confusion. When you translate, the chance of a mistake increases, but let's try. The member of the Federal Public Ministry is always called the Attorney of the Republic. In Portuguese, Procurador da República. The member of the State Public Prosecutor's Office is called Prosecutor of Justice, or Promotor de Justiça in Portuguese, while acting before the first instance of the judiciary branch, single judge, and is called Attorney of Justice, or Procurador de Justiça in Portuguese, when acting in the second instance in the courts of appeal of the judiciary branch. We reach this place when you are older in the career. Sometimes can be a little confused, but that's the choice of the law and we can get used to it, for sure. Well, now let's have a look to the constitutional guarantees of the members of the Public Prosecutor's Office, and which strengthen the character of absolute independence from other state organs. Well, one, for life. In Portuguese, the word is vitaliciedade. After 2 years of exercise until retirement, with a limit of 75 years old, not being able to lose the position unless by a final court decision after a process ensuring full defense. Second, immovability, except for reasons of public interest, upon decision of the competent collegiate body of the public ministry. That's an internal collegiate elected by all members of public ministry and which has alternation of members every 2 years, by the vote of the absolute majority of its members ensuring full defense. That is to say, a public prosecutor cannot be removed from his office unless for reasons of public interest and by decision rendered in an administrative proceeding before a collegiate body of the superior administration of the public ministry, with a vote of 2/3 of its members. Full defense always assured. With that, the functions of that position are preserved. For example, if the prosecutor is leading an investigation against someone important, political pressure movements cannot take him away from the investigation. Once the case has been distributed to that prosecutor, and this is according to the prerogative of the office and by lot, no one can remove him or her from the investigation. Third, irreducibility of subsidy, as provided for in the legislation. This means that the public agent cannot be affected in their remuneration, which are a reduction in the amount. It is clear that there are factors such as inflation that imply the loss of purchasing power. But that is not what the article of the Constitution is about. It intends to protect the member of the Public Prosecutor's Office against possible retaliation from his boss, the state, and allow a dignified life in the face of the challenge that he or she has to face. Among the challenges, we have to talk about the prohibitions. That is, what the federal constitution prohibits a member of the public ministry from doing. The prosecutor or attorney of justice cannot receive in any capacity and under any pretext, fees, percentages, or procedural costs. Cannot practice law. Yes. Participate in a commercial company in accordance with the law. There are limitations. Exercise, even if temporarily away, like by a type of punishment that excludes the exercise of office until the final judgment of the case being accused, any other public function except one of teaching. Cannot exercise party political activity. Cannot receive under any title or pretext assistance or contributions from individuals, public or private entities, subjected to exceptions provided by law. Cannot practice up to 3 years after retirement or resigns as a lawyer in the same court in which served. So it's important to have in mind that for the member of the public ministry is required full dedication, and the only chance of being able to exercise another function is that of a teacher. Prosecutors may not have political activities or be a lawyer in an office or function in a private company. These are similar to that of judges, and these apply to those who entered the institution after August 5th, 1988. That is the date of enactment of the Federal Constitution of Brazil. Let's talk now about institutional functions, that is, what the public ministry effectively does. Privately promote public criminal action in accordance with the law. Only the member of the public prosecutor's office can initiate proceedings in the criminal area, with a few exceptions, such as crimes against honor, for example, in which the offended party can initiate the process himself or herself. This ensures that society has an exempt body to carry out the accusation, and that the accused individual can have ample opportunity to defend himself or herself before the judiciary. Second, ensure the effective respect of public authorities and services of public relevance to the rights guaranteed in the Constitution, taking the necessary measures to guarantee them. This whole is similar to the role of an ombudsman. It points to the effective defense of the population's interests before the public administration and the limits of the state power's performance. The public prosecutors must promote civil investigation and public civil action, like the class action in US. These are the practical instruments for investigation and movement of the judiciary power aiming at protecting public and social assets, the environment, consumer relations, indigenous and minority rights, in addition to protecting people against racism and other disruptive factors. The importance of this issue is noteworthy because we have a difference in relation to several public prosecutors in other countries, which do not act in the civil area, in the protection of collective interests in diffuse rights, and also in unavailable individual interests, limiting their performance to the criminal area. Another important function here is to promote the action of unconstitutionality or representation for purposes of intervention by the Union and states in the cases provided for in the Constitution. This means that the public ministry is entitled to challenge before the courts the laws that it considers to have violated the text of the Constitution. If there are co-legitimates for such action to contest any law, the public prosecutor's office must necessarily participate in the process. For the purposes of representation, for the intervention of one entity in another, union in the state and state in the municipality, only the public ministry can represent before the courts. In order to act, investigate, etc., the right to issue notifications in administrative procedures within its competence is guaranteed, requesting information and documents to instruct them in accordance with the respective complementary law. It is mandatory that the requested documents be provided to the public prosecutor's office. Otherwise, the person who refuses will be liable for the crime of disobedience. It is also a function of the public ministry. Exercise external control of police activity in accordance with the law. To the extent that it is the holder of the criminal action, that is the public prosecutor's office, is the recipient of the investigative police inquiry, it must then be able to use the mechanisms provided for by law so that it can control the activity of criminal investigation. Thus, it can and should request the initiation of a police inquiry if there is news of a criminal fact, and also control the acts carried out therein, indicating steps to be taken and controlling the deadline, always indicating the legal grounds for its manifestations. Finally, it must perform other functions that are conferred upon it, provided that they are compatible with its purpose, being prohibited from judicial representation and legal advice to public entities. One of these other functions is to make the fiscalization of the elections around the country, federal, state, and municipal scope. Remember that the elections here in Brazil are organized by the judiciary power. It is the responsibility of the public ministry, among other activities in this area, to supervise the application of the electoral law, defend the jurisdiction of electoral bodies, promote the investigation to investigate abuse of economic power or abuse of authority, combat illicit or irregular propaganda, monitor the enlistment of voters and the inspection of bookkeeping, and also the accountability of candidates and political parties, as well as challenge the application for registration of a candidacy if irregular. In addition to overseeing electoral claims and failing an action challenge the elective mandate if necessary, in addition to promote criminal actions for electoral crimes. It's an important function, this one. Already forwarding the speech to the end, I must remember that the functions of the public ministry can only be exercised by career members and never by someone outside it, who has not been submitted to the respective exams. To be a prosecutor, you must submit yourself to a public examination of evidence and titles, ensuring the participation of the Brazilian Bar Association in its realization, requiring the Bachelor of Law at least 3 years of legal activity, and observing, if in the nominations, the order of classification. Once chosen the position or place of work, the prosecutor must reside in the district, unless he or she has authorization from the Attorney General to reside in another city. There is also a national collegiate called the National Council of the Public Ministry, composed today of 14 members appointed by the President of the Republic, after approval by the absolute majority of the Federal Senate, for a term of 2 years with one permitted renewal. It is composed of the Attorney General of the Republic, its President, members of the Federal Public Ministry, State Public Ministry, magistrate, lawyers, and citizens elected by the legislative branch, whose functions is to oversee the finances and administration of the different public ministry throughout the country, and compliance of the functional duties of its members. The accounts of the public ministry are also audited by the courts of accounts. These are auxiliary bodies of the legislative power, which carry out audits on public expenditures. Thus, even though the public ministry is an independent institution, it is certain that there is control in the checks and balance system. Thus, the effective action of the members of the public ministry in defending society and the federal constitution is guaranteed, while at the same time avoiding abuses or deviations. It's important to note that the public ministry is a defender of society and therefore is not a defender of the interests of the state itself. For the defense of these interests, there is another legal figure of its own. For example, in the federal central government, the Attorney General of the Republic is not to be confused with the person of the Attorney General of the Union. This one, despite also chosen by the President of the Republic, don't need approval of the Senate and can be dismissed at any time. Remember, the Chief of Federal Public Ministry can just be impeached with the authorization of the absolute majority of the Federal Senate. The same happened in the states, where the Attorney General of Justice is not to be confused with the State Attorney General, who is linked to the executive power. The first defends society, even against the state, while the second defends the government's interests. It is healthy that such roles are not confused in the same person, because interests can be conflicted. In fact, as a rule, they are. Well, it's true that this speech only sketches the profile in a superficial way, and that much more could be said. But I hope that you, who are watching, may have understood a little about the public ministry of Brazil and how the Brazilian Federal Constitution brought about an advanced institution in the concept of defending interests of society and democracy. I am grateful for the invitation that was made to me for this speech. And I hope that one day, one of you will be able to make a personal visit to the public ministry of the state of São Paulo here in Brazil, an institution that I belong to. Anyone who wants to know it virtually can access www.mpsp.mp.br. Again, in Portuguese, M for ministry, P for público, S for São, P for Paulo, dot M for ministry, P for público, and dot BR from Brazil. My final words: be at peace, and let us all continue to fight for the defense of the freedoms of people and society, and also for the preservation of the texts of the Constitution throughout the world. Thank you very much.